It's time for Talk Law Radio with Todd Marquardt. Todd Marquardt, attorney at law in Texas. If you're a millionaire or a thousandaire, Talk Law Radio is now on the air. Call in with your business law question, your elder law question, veteran aid, Medicaid, build a business to get paid. 210-308-8867. Or ask a question online at marquardtlawfirm.com. That's MARQUARDT lawfirm.com. And now it's Talk Law Radio with Todd Marquardt.
Welcome to Talk Law Radio. I'm Todd Marquardt. On the radio, on podcasts everywhere, on Facebook Live, and on YouTube. Also, check out talklawradio.com to listen to archived editions of the show. Today, I'm going to be talking about a specific court case here in Texas. It was a state appeals court in the Beaumont region, and it's about some dangerous deeds that were done. And I'm not talking about dangerous actions that somebody took. Well, that too, but more specifically, actual deeds of conveyance of land. You know, I like to talk about the law to help you discover your legal issue blind spots by listening to me talk about the law on the radio. And today's legal issue blind spot is doing legal work on your own without legal advice. Now, I don't know the parties to this case. I can only speculate as to what happened. The court does write down certain facts of a case, but we don't know everything that happened. I wasn't at the trial, but the fact that there was a trial means that something went wrong. So this is the case of Fogal versus Fogal in the Beaumont State Court of Appeals, and it's regarding an appeal by an adult child that didn't like the outcome of a trial brought by another adult child. And so I'm thinking that this is a mother that maybe only had these two sons. So just imagine some of the facts that may have been with me. We can try and fill in the blanks. So there was a mother, I think her name was Marjorie, who had a family trust. And we don't know exactly what kind of trust it was. Some family trusts are revocable, some are irrevocable, meaning they cannot be changed. Some are living trusts, and some are irrevocable grantor trusts. You can name a trust pretty much anything you want to name it, so the fact that it was named Fogal Family Trust doesn't really give us the details of the trust. All we're told is that the mother, Marjorie, signed a deed from herself as trustee of that trust to her son, Todd Fogal. I'm not making that part up. It's kind of funny to me that the guy's name is Todd, because there's not a whole lot of people out there in the world who are named Todd. It's a name that's reserved only for very special people, so I don't know how Todd Fogal got mixed up in this. But the facts are that Mother Marjorie Fogal signed a deed to herself and her son Todd Fogal as joint tenants with rights of survivorship. So let me talk about what joint tenancy is. That's a type of real estate ownership. In Texas, you can look it up in the Texas Property Code, Section 101.002, effective joint ownership of property. If two or more persons hold an interest in property jointly and one joint owner dies before severance, the interest of the decedent in the joint estate does not survive to the remaining joint owner or owners and passes by will or intestacy from the decedent as if the decedent's interest had been severed. So that's the general rule. But in Section 111.001, there is a right of survivorship in agreements. Notwithstanding Section 101.002, two or more persons who hold an interest in property jointly may agree in writing that the interest of a joint owner who dies survives to the surviving joint owner or owners. So that's why when we began talking about this, I called it joint ownership with rights of survivorship. You can have a right of survivorship on a checking account or savings account. You can also have it on real estate by deed. Well, after she signed that deed, I think it was 2008 or something like that. The date isn't important, but the order of events is important. She signed another deed, a life estate deed, to her other son. Trying to remember. I don't remember his name. I was stuck on Todd, the other son, but it'll come to me soon. So she signed another life estate deed to her other son, and then she died sometime after that. And the other son filed a partition lawsuit so that the court would order that the property be sold or divided between them two. And son Todd Fogal didn't like that. He opposed that move by saying that he was supposed to get all of Mom's interest in the property by right of survivorship. And so the legal question here, the legal issue is whether one of the parties to the joint ownership property can destroy the right of survivorship by signing and executing a subsequent deed of some kind. And so I want to talk about the partition lawsuit because that does come up pretty frequently. See, when two people are owners of the same property, the law will not force them to stay together. It's like a forced partnership, and the law doesn't like to force people to work together. And I just found the guy's name. The other son is Neil, another 4-letter word. So Neil is the one who wanted to get at least one half of the property, because Neil wasn't saying that Todd shouldn't have any of the property. He was just claiming his mom's 1/2 interest and saying that the judge needed to order them to be divided because Todd wasn't going to cooperate. So already you can see that there are some blind spots here. So first of all, I'm thinking, if Mom had a trust, why would she deed property out of the trust? And the only thing I could think of off the top of my head was maybe she didn't understand the trust, the purpose of the trust. And I've had a client or two that thought that way. By the way, if you're confused about your legal documents, you should really ask about them. There was a prominent attorney in town that's no longer practicing, and some of his former clients have been coming to me because they're worried about the legal effect of their estate planning documents. And I'm hearing a common thread from some of these clients that they don't understand what they've got. So if you have legal documents that you don't know or you're uncertain about, you're confused about, call the lawyer that drafted them and ask for an explanation. Or call another attorney that focuses on business and estate law, and maybe you can get an explanation. Okay, so I was talking about the deed from Mom's trust to Todd Fogal, and then a subsequent deed from herself as an individual to Neil Fogal. And Neil brought a lawsuit for partition. So what I was saying is that joint owners of property are not going to be forced to live at the same property together. They're not going to be forced to operate the same property as a business. So there's a method and mechanism where they can go to court and ask for the property to be divided. This joint accidental or unfortunate joint ownership with somebody you don't like does happen a lot by inheritance, because people that die without a will well, somebody's going to inherit their property, and they end up owning this property together, even though maybe they don't know each other or they don't have a good relationship with each other. So a few years ago, the legislature in Texas updated the procedure for partitioning property among heirs. That's HEIRS. Not the rabbit, but people that might inherit from you, people that are related to you, are also called heirs. And this is from Chapter 23A of the Property Code. And so under that special procedure, property can be partitioned, or the property can be partitioned by dividing the property, by establishing new boundaries for each party, or it can be partitioned by sale, where the court orders the property to be sold. Okay, so that was what Neil brought. He brought an action for partition, and Todd opposed that. And Todd also filed a lawsuit for declaratory judgment in opposition for that. So I wanted to explain what that means. A declaratory judgment is a binding adjudication that establishes the rights and other legal relations of the parties without providing for or ordering enforcement. So it's to settle things. But here's what gets interesting is that Neil, or his attorney, said that wasn't the appropriate opposition. It's not the right kind of lawsuit to determine the rights of landowners. Instead, there's another thing called trespass to try title. It's regarding who are the owners on the title of the property. A trespass to try title action is the method of determining title to lands, tenements, or other real property. So that's just how parties to lawsuits bicker, which brings me back to the family trust that Mom had. If she wanted different beneficiaries of the trust, and let's assume it was a living revocable trust that she could change, amend, or restate, she could have simply amended the terms of who would benefit from the property after she passed away. And this may have been a better method than doing a deed to Todd as joint tenants with rights of survivorship and then doing another deed, a life estate deed, to her son Neil. It just seems out of place because you go through a lot of time and expense to set up a trust. Why wouldn't you then use it? And by deeding the property out of the trust, it meant that the terms of the trust would not control the disposition of that property upon her death. So there's this lawsuit going on in the background, and the trial judge said that Todd's declaratory judgment action was not the correct proceeding, and agreed with Neil that the property should be partitioned. So why would that be? Remember, the issue is whether a joint tenancy with rights of survivorship could be cut off from the survivorship provision if one of the joint tenants made a subsequent deed. And what's interesting about this case is that although there is a joint tenancy statute, there's no tenant in common statute. So tenant in common is sort of like joint tenancy, except it's a little bit different. Texas recognizes two types of co-tenancies which may be deeded: a tenancy in common and a joint tenancy. Under a tenancy in common, the deeded interest descends to the heirs and beneficiaries of the deceased co-tenant and not to the surviving tenants. So we do have that established by law. So because there wasn't a statute on point that said that a joint tenancy with right of survivorship could be changed to a co-tenancy by having one joint owner deed a subsequent deed after the joint tenancy was created, the court had to look to some older law. Well, where did the United States get most of its law from on the founding of the United States of America? That's right, from English common law. Common law is opposed to codified law. Common law was the law of courts, court opinions, and that's different than codified law, which is law that's all written down by statute. So now we do have a lot of our laws codified by statute, but sometimes we still go back to English common law. If that's confusing to you, don't worry. This is what law students had to learn in the first year of law school in order to figure out how the law is organized and stuff. So the court found at English common law, creating and continuing a joint tenancy required four coexisting unities: the unity of interest, the unity of title, the unity of time, and the unity of possession. Under the common law, when a party disposed of their interest in property held in joint tenancy, disposal by one of the joint tenants destroyed the unity of title, which destroyed the joint tenancy. The effect of a conveyance on the requirements of unity. So it could be destroyed, as if one joint tenant conveys his estate to a third person. Here the joint tenancy is severed and turned into a tenancy in common, for the grantee and the remaining joint tenant hold by different titles, one derived from the original, the other from the subsequent grantor. So isn't that interesting? Now there was a legal scholar named Blackstone who wrote down a lot of the common law. So you might hear me reference Blackstone from time to time. To the extent the law in Texas on joint tenancies is developed, our law is not inconsistent with English common law. So I just want to recap some of the blind spots here. So the first blind spot is, if you have a trust, do you know what your trust is for? Do you know what the reasons for setting it up were? Do you know what it means? Do you know how it works? And secondly, if you want to change the method of naming beneficiaries or leaving an inheritance, you should probably talk to a lawyer about that. And I'm just imagining that Mother Marjorie didn't talk to a lawyer about deeding the property out of her trust as joint tenancy with rights of survivorship to Todd Fogal, to her son. Maybe he came up with that idea. Maybe he said, "Mom, this is what I want you to do." And then maybe Neil, the other son, found out about it and came up with the idea, well, I want a deed too. So I sort of think of these guys. Remember, I don't know them. I'm just speculating from the opinion. But maybe these were like prodigal sons. Remember from the Bible, the story of the prodigal son? One son asks his dad for the inheritance and goes off and enjoys life and wastes all the inheritance he got from his dad. And he finds himself eating the slop that the pigs are eating, that he's forced to work for because he ran out of money. And decides that it would be better for him to be a slave for his father than to continue living that way. And so he comes back home to his father, and the father greets him warmly with a robe and a ring and throws a party. And so maybe that's what this is like. But we learned that a joint tenancy with rights of survivorship can be changed when the person signs a deed to give part of her property to another person, in this case her son. When the case mentioned life estate I thought, well, maybe people don't know what that is, so I thought I would just define it. And I didn't think that there was a statute regarding life estate because I learned it as part of the common law. It's a type of a way that you can own property. You can own all of the property or you can own part of the property. In a life estate, it's like owning part of the property. So I found the definition in the Health and Human Services Code. It's actually a Medicaid rule in number 1, Texas Administrative Code, section 358.350. And I'll read to you this long definition, so try and stay awake. A life estate provides a person, for the person's lifetime, in this case, Mother Marjorie, certain rights in a property, while transferring ownership of the property to another person. So Mother Marjorie transferred her property, whatever that was, in this case, 1/2, to her son Neil, but she reserved a right to live there for the rest of her life. The duration of a life estate is measured by the lifetime of the owner of the life estate or by the occurrence of some event. The contract establishing a life estate, however, may restrict one or more rights of the owner of the life estate. The owner of a life estate does not have fee simple title to the property nor the right to sell the entire property. Those are rights that can be reserved. Let me back up. The joint tenancy with rights of survivorship deed didn't have any certain restrictions on Marjorie. It didn't say, thou shalt not deed your interest to anybody else. So she could do what she wanted with her 1/2 interest. Now, usually, if you only own 1/2 of the property, a 1/2 undivided interest, nobody really wants to buy that from you because then they would have to share with Todd Fogal. Does that make sense? If you only own 1/2, that's not very marketable because then they would be whoever bought that or whoever it was given to would be forced to be owners with somebody they didn't know or who they didn't like. So that's a life estate. Since we're talking about life estate, I want to mention another type of life estate known as an enhanced life estate deed, or commonly referred to as a ladybird deed. It's defined by Black's Law Dictionary, 11th edition, 2019, that it's a deed that allows a property owner to transfer ownership of the property to another while retaining the right to hold and occupy the property and use it as if the transferor were still the sole owner. And they reserve the right to sell the property and keep the money for themselves. So that's interesting, isn't it? I've been talking about a lot of stuff today. All these are hidden legal issue blind spots that you might want to talk to a lawyer about. I wanted to give a disclaimer that the State Bar of Texas wants us to talk about this kind of thing, but legal advice must be tailored to the specific circumstances of each case, and laws are ever changing, so material discussed today is meant for general informational purposes only. Also, Marquardt Law Firm sponsors this show, and attorneys at Marquardt Law Firm focus on business and estate law. Search for Marquardt Law Firm online or go to marquardtlawfirm.com for more information. That's M as in mother, ARQUAR, D as in David, T as in Timothy.com. Finally, I wanted to pray. I want to pray for those, dear Lord, for those who have prodigal children who want an inheritance more than their family harmony. Please be with them and help them through these trying times. I pray for those who need trusted advisors but have not yet found them. Help these folks find trusted advisors to explain how to get things done legally. I pray also for those who need help understanding complicated legal concepts, issues, and principles. Please help them to find the information that they need. If you enjoyed this program, please like, follow, subscribe us on Facebook, Instagram, YouTube, Twitter, X. You can find us in a lot of places. That's it for today. Thank you. I'll talk to you later.